Came across an interesting case during the week there in the newspapers. It's a personal injury case. High Court had awarded €53,000 to a woman over a knee injury that she sustained during a stock take in a petrol station. Now, when I saw a stock take in a petrol station, it piqued my interest because I have a background, about 20 years of experience of petrol stations and doing stock takes. So it kind of puzzled me, to put it mildly, as to how somebody could injure themselves doing a stock take. Nevertheless, that's what occurred in this case, and the lady in question, she was a trainee assistant manager in a Topaz petrol station. She was doing a stock take. She was hunched down, apparently, on her knee or on her knees, and that's important, counting the magazines. When she stood up then, her knee popped, and when her knee popped, she suffered a bucket handle tear of the lateral meniscus of her right knee. She sued Topaz and she went to the High Court with that claim. Topaz denied liability. Mr. Justice Robert Eager awarded the claimant €53,682 plus costs in the High Court. He said there appeared to be no measures addressed in training with regard to lower limb injuries, apart from lifting weights. So remember, she's down on the ground squatting, or claiming to be squatting, basically counting magazines on a shelf that was low down, or in a stock taking, or in a stock press. The High Court found that the employer failed to carry out its duty to identify risks for the task of stock taking at a height or level that required kneeling or squatting, and that appropriate equipment had not been provided to prevent injury. And the award, as I say, was €53,682. An engineer gave evidence on behalf of the claimant and said that her large build probably increased the risk. Topaz appealed the award, however, and it went to a 3-judge Court of Appeal. They set aside the award and said that there was no credible evidence before the trial judge which could support the finding of liability against Topaz. If the Court of Appeal says that there was no credible evidence before the trial judge which could have supported his finding of liability against Topaz, how did he arrive at that finding? That's the first question that crossed my mind. CCTV footage of the incident was not viewed by the engineer or the legal team of the claimant or herself until the morning of the trial in the Court of Appeal. And when they looked at it, according to the Court of Appeal, it showed something quite different from the case made by the plaintiff up to that point in time. It showed she squatted on her left knee, but critically was kneeling on her right knee. And this is not what she said, because right up to the commencement of the trial, her case was premised solely and exclusively on an injury she suffered as a result of prolonged squatting. Topaz came to court to meet that case, which was, according to the Court of Appeal, entirely abandoned without a backward glance by the plaintiff when it emerged from a viewing of the CCTV that, in truth, this is not how the accident happened at all. I love the phraseology there and the wording by the Court of Appeal, whoever wrote that decision, entirely abandoned without a backward glance. I have a vision of Topaz employee or former employee or petrol station employee walking out of the High Court, having discovered that the CCTV did not support her case at all, and walking out without, as the Court of Appeal described, a backward glance by the plaintiff. Interestingly, the Court of Appeal said something else that I found very, very interesting, and for a person who likes reading, who likes words, who thinks that words matter, and who finds great amusement and great entertainment and great diversion in some of the decisions from the High Court and the higher courts, the Supreme Court and Court of Appeal. Some of the wording of the judges is well worth a read, and if you are interested in words, if you're interested in language, if you're interested in reading, some of the judgments are well worth reading for the phraseology that's used. Some of it is archaic, but it is excellent. But in this particular case, the Court of Appeal said that the logical consequence of the position adopted by her engineer was that every employer would have to have every employee or prospective employee medically vetted to decide whether they might be subject to particular risks, requiring a bespoke risk assessment to be carried out, the judge said. It cannot be seriously suggested, the court went on to say, that the employer, by looking at a person, is to decide whether special medical assessment is called for, he said. And this is where the language gets good. It says, such a proposition has only to be stated to demonstrate its absurdity. So the conclusion of the trial judge as to the foreseeability of this injury was not unsupported by credible evidence, he held. So Court of Appeal set the award aside. The proposition has only to be stated to demonstrate its absurdity. It's a particularly good phrase, because the next time you come across somebody who is trying to argue with you about the earth being flat, or Wednesday not coming after Tuesday, or about the anti-vaccine brigade, you can say such a proposition only has to be demonstrated, or only has to be stated to demonstrate its absurdity. Anyway, hope you find the video useful. It is to do with the personal injury claims. High Court, its negligence, CCTV footage did not support the contention of the plaintiff, and the argument, again, as I say, across my mind was how the High Court judge found liability against Topaz when the Court of Appeal said that there was no credible evidence before the trial judge which could have supported his finding of liability against Topaz. Hope you find the video useful. If you do, I'd appreciate if you would give it the thumbs up down below. Thanks a lot.